Hi students, so in this new video we will check it out the capacity of parties or the capacity of persons entering into a contract. And section 10 of the Indian Contract Act 1872 deals with the capacity of persons. Section 10 of the Indian Contract Act says who all are not capable to enter into a contract. So we will check it out who all are not capable. A minor is not capable to enter into a contract. Minor means a person who is less than 18 years of age. Then a person having unsounded mind. And then a person who is disqualified by the law. It could be an alien enemies or any foreign sovereignties. We will check it out. Who is a minor? Or under Indian law, who is a minor? The Indian Majority Act specifically says that the person who is under the age of 18 years is a minor. In early times, if guardian is appointed by the court, then for that child, when he attains the age of 21, then only he would be considered as a minor major person. And later, an amendment made to it, and then the age of majority is made equal to everybody. So the age of majority is 18 years. Those who are below the age of 18 years will be considered as minors and not capable to enter into contract. Now we will check it out an example, and here A is a major person, and he offers his coat to B. B is a minor. And A said that, yes, I'll sell my coat or I'll give my coat to you, but you have to pay 3,000 rupees to me. So B is a minor, but he accepts the offer and pays rupees 3,000 to A. But later, A states that the contract is void because it was entered with a minor. So after receiving the 3,000 rupees from the minor, being aware that B is a minor, but still A accepts 3,000 rupees from B, and then he argued that that contract is a void because B is a minor. But in this case, the court held that even if the contract is entered with a minor, still it is enforceable. Why? Because in this particular contract, the minor has performed his part of obligation in the contract. What was his part of obligation? Because what he promised to A, yes, I will pay 3,000, you give me your coat. So here B, being a minor, still paid 3,000 to A. So the court states that this contract is not void because B, being a minor, has performed his part of obligation in this contract. In Indian Contract Act, it does not answer whether an agreement with a minor is a void or voidable one. What court has practiced is they made rulings based on the facts and circumstances of each cases and on the basis of principle of equity and natural justice. Since it is not specifically answered in our Indian Contract Act is whether an agreement with a minor is a void or voidable one. Now we will look into a landmark case, that is Mohori Bibi versus Dharmodas Ghose. I think the pronunciation is correct. So in this case, Mohori Bibi is a plaintiff, and the plaintiff was a minor. So he mortgaged his property to the defendant. Defendant is a money lender. So Plaintiff is a minor and defendant is a major. Plaintiff mortgaged his property to defendant, who is a major, and secured a loan. And here also the defendant was aware that this plaintiff is a minor. Then this defendant later on argued that or made his submission that both the parties were aware about the minority of the plaintiff at the time when they entered into the agreement. So the doctrine of estoppel cannot exercise. But here the court said that no, here in this case the agreement is with a minor, so it is a void one ab initio. Void ab initio means void in the very first instance itself. But here the defendant made the submissions to refund the loan amount if court is going to declare the mortgage as a voidable one or void one. But here the court held that no, this agreement is a void one or it's not a valid one because it's void ab initio. Now we will check it out. Consent. Consent of the parties is how much important in a contract to term it as a valid contract. So section 13 of the Indian Contract Act defines the term consent, and it defines the consent as when two persons agree on the same thing in the same manner, we can say that it is a consent. I repeat, when two persons agree on a same thing in the same manner, then we can say that yes, there is consent from both the parties. And the Act specifically says that this consent should be a free one. It should not be made by coercion, and there should not be any undue influence. There should not be any misrepresentation, and it should not obtain through fraud or mistake. If it's proven that one's consent is not a free consent or not obtained through a free one, then later on the contract will be termed as a voidable one. Now we will check it out an example. In this example, A threatens B that he will kill B if B not given his house to A. So B, out of fear, signs the contract and sells his house to A. Here it's very clear that the consent of B has been obtained through a threatening, or A has threatened B to obtain his consent. So it's not a free consent. So here B has a possibility, or B has a chance that he can avoid the sale on the ground that he was compelled to sign the contract. Whatever consent he had given, that he agreed that yes, he will give his house to A, but he gave his consent just because of the threatening from A. So here the consent of B is not a free consent. It's obtained through coercion and under influence. So we can term that contract is a void one.